Welcome to topic 5.2. What are your criminal rights? By the end of these notes, you should be able to identify what your rights are when interacting with the police in different situations. The first key question is the obvious one. Well, what are your rights if you're stopped by the police? The answer, it turns out, depends on the situation in which you're being stopped by the police. For instance, if you're stopped by the police in public, you don't have to answer any questions asked. If they ask you where you're going, what are you doing, where do you live, you don't have to give them any of that information. However, it is important to note that you should be polite at all times when refusing to answer their questions. Now, recent court cases have said that you have to say that you want to remain silent. The act of being silent is not enough. You actually have to state the words, "I am choosing to remain silent." At that point, they're not allowed to ask you any more questions without a lawyer present or, if you're a minor, your parent. It's also important to note that it is not a crime in Wisconsin to refuse to identify yourself to a police officer unless you are being detained or arrested. But refusing might make the police suspicious about you, and that'll have some implications we'll talk about in a little bit. Now, note, this says that you don't have to identify yourself if you're not being detained or arrested. But if you are being detained by the police or you are being arrested by them, then you do have to identify yourself when asked. How do you know if you're being detained or arrested? Well, if you're being arrested, it's pretty obvious. If you're being detained, they have to tell you that they're detaining you. You also do not have to consent to a search of yourself or your belongings. This does not mean that they can't search you. It just means that they have to cross an extra hurdle to prove that they had what's called probable cause to suspect that they'd find something illegal on you if they searched you. So if you say, "Yes, you can search me," they can use anything they find on you in court against you. If you refuse to consent, they can still search you, but it'll be a little bit more difficult to use anything they find on you in court against you. The courts have ruled that police may pat your clothing down if they suspect that you might have a weapon. The reason behind this is because the courts have said that being an officer can be dangerous, and so they need to make sure when interacting with a suspect, that suspect doesn't have something on them that could immediately harm the officer in question. If they feel a weapon under your clothing when they're patting you down, they are then allowed to search for that weapon and use it against you in court. Of course, that's only if the weapon was obtained illegally or was used as part of a crime. I do want to emphasize over and over again here that refusing to consent may not stop them from carrying out the search against your will, but making a timely objection at the time in which they're trying to search you, stating, "I do not consent to the search," when you make that objection before or during the search, can preserve your rights in a later legal proceeding. What this means then is that if you are telling them, "I don't consent to the search," and then they find something that they want to use against you in court, they're going to have to prove to a judge and a jury that they had the right to do that search in the first place. Otherwise, anything they find will not be able to be used against you to prove your guilt in court. Again, I want to emphasize, you do not have to answer their questions. You don't have to tell them where you're born. You don't have to tell them if you're a U.S. citizen. And you don't even have to tell them how you entered the country if you're not a U.S. citizen. They cannot force you to say these things. Now, it's important to note that when dealing with police officers, they do have weapons and they are allowed, according under law, to defend themselves. If they feel at risk, they can use lethal force to defend themselves. So it's important to know how to reduce risk to yourself in all interactions with the police. The first step is, whenever interacting with the police, stay calm. Never ever act out of emotion. Do not run. Do not resist. Do not obstruct the officers in any way. That means don't get in their way when they're trying to do their job. You can be charged with resisting arrest even if you did not commit a crime that they're searching you for or claiming you did in the first place. Under no condition, do not lie to them or give them false documents. Again, you don't have to identify yourself. You don't have to answer their questions, so there is no reason to lie. If you do so, that can get yourself into even more trouble down the line. It is also crucial that you keep your hands where the police can see them at all times. There are far too many stories of people interacting with the police, and the officers claim the person had a gun, shoots and kills that person, when it turns out the person actually had something else in their hand, like a book or a spatula or a top of a hose or a wrench or a wallet or a brush or a soda can or even a pear. So at all times, keep your hands where they can see them. As a minor, if you're under the age of 18, they need to have your parents or lawyer present whenever questioning you. Now you might be thinking, Mr. Dunbick, this isn't fair. The police are supposed to be there to protect us. Why should I have to make the officer feel comfortable? Unfortunately, that is just the state of things, where officers, the courts have said, have a very risky job and they have a right to defend themselves. And so it is our job when interacting with them to make them feel safe. Is it fair? No. But unfortunately, that's just the way our legal system works. If you're driving and you're pulled over by the police, both the drivers and the passengers have the right to remain silent, that is, to not answer any of the cops' questions. If you are a passenger in the car, you are free to ask the officer if you are free to leave. If they say yes, you can leave silently. Don't do it suddenly, don't sudden moves, keep your hands where they can see them, walk away quietly. In most cases, they're probably not going to let the passenger leave, though. Just a heads up on that one. To reduce risk to yourself when being pulled over by the police, make sure you stop the car in a safe place as quickly as possible. Do not make them chase you, but pull over as soon as you can safely do so. If it's at night, try to park directly under a streetlight or some other source of light that makes it easy for the officers to see what's happening inside the car. As soon as you are pulled over, but before the officers reach your door, it is important that you turn the car off and put it in park. Turn on the internal light so they can clearly see anything in the car, and open the window part way and place both hands on the steering wheel. If you're in the passenger seat, put your hands on the dashboard. If you're in the back seat, make it very clear where your hands are and do not have anything in your hands at all. One key difference between being stopped by the police while driving or in a car and being stopped by the police on the street is that when they request it, you do have to present your driver's license, proof of registration, and proof of insurance, so that means you do have to identify yourself. This is because you can only drive a car if you have a valid driver's license, your car is insured, and the car is registered. So you do have to present that to the police as soon as they ask. It's a good idea to have that out before the police actually get to the car door itself. If you do not have it ready before the officer gets there and you just want to have your hands on the wheel so they can see it, do not make sudden movements. Keep your hands where they can see them at all times. If you need to go into your glove compartment box or grab for your wallet in order to provide the documentation they're requesting, before you even move a muscle, tell the officer exactly what you're about to do and why you're going to do it, and then proceed to do so very, very carefully and slowly so that they know exactly what's happening. Remember, a sudden movement can be interpreted as you reaching for a weapon, and that would not end well for you. If the police show up at your door, you should not invite the officer into your house under any circumstances. What you should do when they show up at your door is talk to them through the closed door and ask them to show you their identification to prove that they are in fact officers of the law. You do not have to let them in your house unless they show you a warrant signed by a judge that lists your address as a place to be searched or that has your name on it as the subject of an arrest warrant. If they do present this document to you, then you must let them in or could probably be charged with resisting arrest or obstruction of justice. If they state that they have a warrant, ask the officer to slip the warrant under the door or hold it up to the window of the door so that you can read it. They must present it to you. A search warrant is a legal document signed by a judge that allows the police to enter the address listed on the warrant. Officers can only search the areas for the items that are listed on the warrant, and an arrest warrant has to have the name of the person that they're there to arrest. Even if they do have a warrant to search your property or to arrest you, you still have the right to remain silent and do not have to answer any of their questions. In fact, you should not answer any questions they have or speak to the officers while they are searching your house. Instead, stand silently where you can easily be observed and where you can observe what they are doing, where they're going, and what they're taking. If you can, take notes. Otherwise, take mental notes of it and write it down as soon as the officers leave. These notes could be extremely important when you're on trial. Again, write down everything you observed as soon as you can. It may not be ideal to do it when they're searching your premises because, again, you don't want to make sudden movements, you don't want to seem threatening in any way, but it'll be important for you to write down everything you observe to have that for your court case. So, what happens if you're arrested by the police? During the arrest, again, say that you wish to remain silent and ask for a lawyer immediately. Then you must be quiet. Do not answer any of their questions. In fact, once you say you want to remain silent and want a lawyer, they're not supposed to ask you any more questions. If they do so, that could be a violation of your rights. Don't continue to talk even if they're not asking you questions, because anything you say is now considered voluntarily giving up your right to remain silent. So just stay quiet once you state, I wish to remain silent and I want my lawyer. Don't answer any questions, don't give any explanations or any excuses. Nothing you say will convince them not to do what they're doing. Instead, be quiet and get a lawyer. You will not be able to convince them not to carry out their actions. It's not even worth trying and can in fact get you in more trouble. So just keep your mouth shut. You do have a right to a free lawyer paid for by tax dollars in case you can't afford a lawyer. Now, these public defenders, they do their best, but they're generally underpaid and overworked. If you can't afford a lawyer, it's better to go with a private lawyer. Now, again, don't say anything. Don't sign anything, and do not make any decisions without a lawyer present. Even a public defender, again, they're doing their best, and a lot of them are really good lawyers. They're just overworked and underpaid, but they are much, much better than going it alone. Always have a lawyer present. You have the right to make a local phone call when arrested. The police cannot listen in if you are calling a lawyer. However, they can and probably will be listening in if you choose to call anyone else. Keep that in mind when calling someone, because anything you do say probably will then be used against you in a court of law if it makes you look guilty. When on the phone with your lawyer, probably best to leave it vague. Don't get into too many specifics either, just in case. At the trial, they must tell you what you're being charged with. This is so that you can prepare the best defense for yourself possible. Now, again, I say you prepare it, but really it'll be your lawyer preparing that defense on your behalf. Never represent yourself. It's just a bad idea. Once you are told your charges at the arraignment, you either have to stay in jail waiting for your trial date, which can take months, or you can pay bail to go free until then. Now, you'll get that money back if you show up for your trial date. However, if they see you as a too potentially high of a flight risk, meaning you might run away, or you might not show up, or your crime is that you're being charged with is an extremely violent one, they may not actually let you pay bail, and you'll have to remain in jail until your trial date. The trial must follow protections laid out in the Fifth and Sixth Amendments. This means they have to have a trial by jury. You don't have to testify against yourself. You have a right to a lawyer. You have a right to see evidence against yourself. You have a right to ask questions of witnesses that say they saw you did it. You have the right to have your own evidence presented to show that you're innocent. You have the right to have your own witnesses to prove that you're innocent. So trials must follow the Fifth and Sixth Amendments. Now, in order for the government to punish you, all 12 members of that jury must agree that you are guilty beyond a reasonable doubt in order for that punishment to take place. Reasonable doubt just means that any reasonable person, given the exact same information, would come to the conclusion that you very likely committed the crime. Now, notice, this doesn't mean that they have to be absolutely 100% sure that you committed the crime. It just means that, given that information, a reasonable person would come to the conclusion there was a high chance that you did commit the crime based on the evidence presented against you in court. Now, if all 12 jurors decide that there was not enough evidence to convict you, the government is not allowed to put you on trial again with 12 new jurors. They just gotta let it go. You might be asking then, what happens if, for instance, one of them or two of them just can't agree with the other ones? That's called a mistrial, and the government then would have a choice to either drop the charges against you or try again with a new jury. So being proven guilty or not guilty, that has to be unanimous. All 12 jurors have to agree. The government has the right to appeal the decision to a higher court, and this just means that a higher court, like the Supreme Court or the Appellate Court, they'll take a look at how the trial was run and make sure everything was done properly. If you're convicted, you also have this right for an appeal. There are two main levels of appeals. The first is the Appellate Court, which is where you go right after the District Court. District courts are where the trials are held. The Appellate Court will just look over the decision and make sure everything was done properly if asked. And then above that is the Supreme Court. So you can appeal to the Court of Appeals, and then if you still don't like their decision, you can appeal to the Supreme Court. Sometimes it goes back and forth. Found guilty in the district courts, Court of Appeals says that your conviction's overturned because the rules weren't followed, and then it gets appealed to the Supreme Court, and they say, actually, no, the rules were followed, and you are going to have to serve out your punishment. So those are the levels of the appellate courts. Again, if the jury can't all agree, if even a single one of them says they have reasonable doubt to think that you did not commit that crime, the government can either drop the charges against you or start the trial over again with 12 new jurors. The conviction has to be unanimous, or the not guilty verdict has to be unanimous. If you're found guilty by all 12 jurors, then you'll be sentenced based on what the law says by the judge. Now, judges generally have a range of punishments they can choose from depending on the crime in question. So it could be probation, maybe a year in prison, maybe it's a fine, right on the low end. On the high end, it might be 10 years, 15 years, 20 years, lifetime in prison. So there's generally a range of punishments the judge gets to choose from. Not in all cases, but in many. Now, you again do have that right to appeal the decision to a higher court if you think your rights were violated. This is where those notes you took during their searching of your property, that's when those would really come in handy. If, for instance, those notes show that the police gathered evidence against you in an illegal way, then they're not allowed to use that against you in court to prove you're guilty. And if they did, and that's why they found you guilty, the appellate court would have to throw out your conviction and tell the government they either have to give you a new trial or let you go. This is because of that concept of rule of law. Even the government has to follow the rules. So, what happens if you believe your rights have been violated by the police or by the court system? Excellent question. When you can, the first thing you should do is write down everything you remember, including the officer's badge number, their name, patrol car numbers, the agency they work for, were they a sheriff, were they a police officer, were they a state patrol officer, were they the FBI, the DEA. All the information will be crucial for helping you out. Get the contact information for any witnesses who saw the police violate your rights. That way, if there's a trial, you can have them called to the stand as a witness on your behalf. If you're injured, seek medical attention immediately and take photographs of those injuries immediately. This way, you can prove that those bruises or any other injury, no matter how small, happened because of your interaction with the police. Then you have to file a written complaint with the agency's Internal Affairs Division or their Civilian Complaint Board. Now, this information should be located on the website of the agency that officer worked for. You can also contact a private law firm, a nonprofit called the ACLU, the American Civil Liberties Union, and if your case has enough merit, they might actually provide a lawyer for you in order to sue the government on your behalf. Now, this lawsuit is not necessarily about getting you money, it's about stopping the government from abusing your rights and the rights of other people. All right, that's the end of the lesson. As always, take a moment, rewrite today's goal at the end of the notes. You can see the goal at the top of this video, the top of your note sheet. Go through and identify 3 facts from the notes that help you understand today's goal. And as always, write at least one question you still have that could help you better meet the learning goal. Remember, you cannot get full credit for your notes unless you do all 3 of these reflections. All right, I'll see you in class whenever we see you.